Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, so welcome to another session of Latte with a Lawyer. Today we have with us, I'm going to try to get the name right again, Bassford Remele, Patrick Newman from Minneapolis, who is a commercial litigation attorney there. And welcome to the show.
Hey, thanks. Thanks for having me. It's a nice way to spend a Friday afternoon for a little bit.
Absolutely. Yeah, we were just talking about going out to play golf. Today is like a perfect day. It's in the low 70s and sunny, and I'm going to try to get out there this afternoon, at least to go to the range.
If you can believe it, there's actually snow on the ground here from last night. It snowed here yesterday.
Wow, that's right.
Yeah.
I saw there was a big storm that came through.
Yeah, it was something else. But
Man.
so you'll see that my firm recently adopted Dress for Your Day. So I dressed to have a latte with you.
Excellent. So, okay, good. That's a good segue. So what's your favorite beverage of choice to get you started in the morning?
Yeah, I go back and forth on the caffeine train. I've ridden it for most of my adult life, but I've made efforts to get off varying degrees of success. But so currently I'm on it, and I like Americanos.
Excellent. But why get off it? I don't understand. What's the need to get off the caffeine train?
Yeah, just overall sort of it helps the calm. It helps the center, I think, a little bit. But then you're also a little you're maybe not as on the ball either without it. So it's a give and a take. And right now with the schedule, I've got two little kids at home too. So
Oh boy.
like I say, we're riding the train.
Yeah, you got to be caffeinated for that. Yeah, my kids are older. You can see the gray here. So I got two now in college, so I don't have to worry about the early days.
Right.
You'll look back in retrospect. You'll cherish those days. You'll realize how easy you had it.
Yeah, I hear that a lot. It's not the first time I've heard that. So I try to remind myself of that when we're having like bedtime rebellion or whatever.
Yeah. Exactly. It's actually pretty easy. I mean, their needs are pretty simple. When they get bigger problems, bigger things.
That's right. More opinions, I imagine.
More opinions. The smarter they are and the more they debate you and challenge you. So that's a whole other level of fun. That's
right. Right.
Anyway. So commercial litigation, tell everybody what you do, what do you do for a living, what kind of work you do.
Yeah. So start from the broad umbrella of commercial litigation. That is so broad to almost not mean anything.
Okay.
That's any dispute that might arise amongst businesses. And we, as a firm, that's what Bassford does. Bassford's at any given time around 50 lawyers, and litigation is what we do. This firm has existed in various forms for, I think, going on like 130 years. So we have a really rich tradition here in Minnesota known as premier litigators. So everybody here does that. We all then have specializations, I guess you would say, niches that we focus on. And mine, aside from just generally working on business disputes, you could probably call financial services litigation, which is another lawyerly phrase that maybe doesn't mean a whole lot. Here's what that means for me. I actually come from a background in the collection industry.
Okay.
So once upon a time, I answered a want ad back when those things existed, like it was literally on a corkboard that I pulled off the ad for a skip tracer. Did not know what that meant, but I needed a job. I was like 19, 20 years old. And turns out it's working for this debt buying company and trying to track down folks who, as the term implies, they skip town. You're trying to track them down and see if you can collect your money. And that led to other jobs in the collection industry and sort of culminated with doing compliance work internally, working on the outside legal process, and getting this thought in the back of my head, maybe I could maybe I could do this for a living as an attorney. And made my way to law school, found my stride. If I'm honest, academically, I wasn't nearly as engaged coming into undergrad until I kind of got that idea that, oh, this is some of these critical thinking skills can be used for something other than going into teaching or writing for a living. That's a tough gig to make a decent living at. So got through law school, and I sort of thought I was done with the credit and collection thing. I don't think any of your audience will be terribly surprised to hear that it wasn't like a boyhood dream of mine to get into credit and collection.
Right.
But I've never been able to leave it on. So I've embraced it. I did some work for a bankruptcy trustee, which that's collection just under a different name. That's a big part of what they do on behalf of an estate, a bankruptcy estate. Then did some plaintiff's work on the collection side, and then moved into a practice which is now national in scope. I defend all kinds of financial institutions from consumer protection lawsuits. Still do the business disputes that we're talking about. A lot of class action defense work, a lot of compliance work too. That's a huge part of what I focus on is what can we do if you've been sued? What's the compliance lesson that we can learn? And even better still, what are some of the compliance protocols we can develop so you don't get sued and we can avoid the problem before it starts?
So financial? So I used to go to Minneapolis years ago in a different business. I used to have Piper Jaffray, and I'm trying to think of the other banks in town. U.S. Bank. What are the other? There's a pretty big financial center in Minneapolis.
True. So you'd have your Wells Fargo has a big presence here. Yeah. What would have been Twin Cities Federal, TCF, they were recently acquired, I believe, by Huntington Bank. But those would be your big ones locally, U.S. Bank.
So would those be clients of yours that you would work for?
We've represented some, not all of those companies, a couple. We do a lot of credit union work.
Okay.
So we get credit union clients, collection agencies, FinTechs. The FinTechs have gotten a lot of pull in the market, especially in like short-term lending and things like that. And so then developing the compliance protocols to keep up with that growth is a huge challenge for them. So a lot of internet-based lenders we do work for, background screening companies, and businesses that do any kind of extension of credit or are concerned about their accounts receivable process.
Okay.
So it's not just banks. We're a lot broader than that. Got it.
Financial services. And are these trials? Do you go to court and like in front of a jury? You do?
Yeah. I've had these go to a jury trial. I've tried jury trials in other contexts. And a lot of these are disposed of on motion before the courts. So the facts often are not terribly complex unless maybe you get into some of the technology driven claims or class claims. Those can get more unwieldy. Right. But if you're talking about an individual consumer with a claim, it's a relatively limited,
straightforward. Yeah. I gave you money, you owe me money.
Yeah, and what was the conduct? What are they complaining about? Right. I will say that when it comes to like credit reports and things like that, that can be a deep rabbit hole. Figuring out sort of what happened and what they're claiming should have happened and that sort of thing. But yes, these cases do get tried. You've done plenty of these shows to know that civil litigation, it's a small percentage, probably 1 in 10, maybe try. And I would say it's a subset of that. It's a smaller percentage still for these. Here's the thing with consumer protection lawsuits. Many of them have what's called a fee shifting provision in them. And so as a business, you have to decide pretty early on, what are we going to do with this case? What are they looking for on the other side in terms of damages? And what is the practice or the conduct that's being challenged? And usually in my experience, these cases get fought for 2 or 3 reasons. One, you've got a plaintiff who's just completely misvalued their claim. They want way more than it's worth. So we're actually in a position where we're saying, nah, we're going to have to fight this. The other is, do we have a practice or conduct that we think is legitimate and ideally is a revenue generating thing that we do, that we have to defend, that we have to go out and we have to get it, lack of a better phrase, blessed by a court, for a court to say that this is okay. And there's a lot of, it's a small industry, so there's a lot of familiar faces and personalities. And so some of that plays into it as well.
Are you normally on the defense side, it sounds like?
Always. On the consumer stuff, always on the defense side. Have done some plaintiffs work in commercial lit, but not a lot. Mostly
Okay.
defense.
Do you work with insurance companies?
We do.
Okay.
Not always. I was about to say it's an even split, but I'm not sure on the percentages. But yeah, plenty of insurance carriers that we work with, but we have a lot of clients that hire us directly as well.
Got it. Interesting. So do you like sort of pine for the chance to get in front of a jury, or would you rather not?
I like it. I just had one
Okay.
November. It wrapped up in November of last year. That was not a consumer claim, but it was great. I really enjoy it. Just an opportunity to get in, craft a narrative and a story and put it on for people. Nothing else like it. It's very, very unique. And you never know. We were fortunate enough, we prevailed in the case. And it had gone on for a couple of years, maybe even 3. Part of that was pandemic driven, but we're fortunate we were able to be in the courtroom, doing it live with the jury. And we put in a good case and felt good about it when we were done. But even then, when you're sitting there and you're waiting for the verdict to come back, you don't know.
You never know, yeah.
You just don't. People talk about jury nullification as if it's some like doctrine or something. And that's just a fancy way of saying the jury's going to decide whose story do they like and who are they going to rule for or give a decision in favor of. And that, I think that's a mistake that gets made, especially for lawyers who don't try cases a lot, or for newer lawyers, is that they go in and they really hammer on the law with the jury. And it's important that you outline that and you get good instructions to the jury about what they should be doing. But really, we're there to talk about what happened and why our client's position is right. And that's going to be fact driven, story driven. That's going up there and telling them what a statute means is you're just going to get a lot of blank kind of.
Yeah, I mean, think about who you're presenting this to, right? They don't have that background and knowledge, right? So it's kind of like with most products, if you look at any technical product, it's like you have to break that down to simple terms for people to understand it, because then they'll never understand it the way you do as a technical or expertise, whatever your domain expertise is. So that's interesting. So I've heard that a lot too from others, no surprise. But how do you prepare for that so you make sure that you have the right story for the jury?
Know your case, and know which parts of it are potentially problematic for you. This is probably another lawyerism that maybe you've heard. Civil litigation in a lot of ways is not always active steps to win. It's defensive steps to make sure you don't lose your case.
So you don't lose, yeah.
Because there's a reason that cases get fought and that they go to trial. And it's usually because the facts are closer than what either side is going to argue. And there's a reason it's not settling, or that the court declined to bounce it on a motion, that you're finally getting to that last step. And so appreciating what's the soft underbelly of your case and knowing how to address that. Because anybody can go in full steam and talk about why this, and this, all 5 of these factors are in our favor. And especially as a defense lawyer, I'm kind of there with my pin popping balloons. Right? I'm trying to poke holes. And if you're not aware of what your opposition is going to do to try to poke holes in your story, then, and juries see that. I've become a lot less cynical having it, been in front of a jury, especially now recently, with their ability to sniff out what's actually going on. Pretty keen, pretty acute. I think juries tend to get it right on the story. And so if they can't connect the dots, and if there's not a good explanation, if there's a bad fact, then I don't know it's going to go so well.
But I guess my question to you is, and I'm kind of leading you down a path for this question, but I mean, how do you know what's going to resonate with them? Like, how do you know what's going to work? I mean, how do you test for that? How do you prepare for that?
Tell the story to people that that are late.
When you say people, like you do focus groups, you do mock trials?
If the case is big enough if the client has the resources, absolutely that happens.
Only if the client, that's interesting. So on the plaintiff side, it's like they get the resources, right? On your side, the client has to approve that budget, right? So how do you got to make the case for that?
Definitely. What's that issue, right? Because it can be, there's such a thing as a Pyrrhic victory. If it costs you more to defend it than it was ever worth, and sometimes that's the right thing to do, that
Right.
there are other factors in play, but it's not cheap to get a jury consultant and a focus group and come in and mock this thing up once or twice. That's a lot of time spent. So you have to make sure that that's warranted. And if it's not, then you find people that you trust and you tell them of course, nothing privileged. You give them what's your case? Give them the elevator pitch of your case and see how they react. And if they don't understand part of it, or if they're looking at you sideways during part of it, that's a really easy way to ferret out where your problems are. And usually you should get, most people hear a story of someone who's been wronged or not. And our tendency, I think, is to pick a side, to say who's right or wrong. And you should get that out of the people around you, spouse, friends. That's why we have a firm too. We'll do this. We'll present these things informally to our partners and say, what do you think of this argument? And they're a good source, but they're not a perfect source because they're trained legal minds.
Yeah, I was going to say, that's not the jury. That's not the makeup of a jury. They're not trained lawyers.
Right, exactly. So you have to be careful with that, but we do that. But yeah, I'll give my.
You bore your friends when you go out to dinner, right?
You better believe I do.
Yeah.
Yes. So yeah, that's right. That's the method.
I would think so. Yeah, that's pretty funny. Okay, so let me ask you this: if you had to think back on like a big case you worked on, or anything, what was the one that sort of stands out that was memorable?
The immediately memorable one was the trial we just talked about, just because it's so close in time. But I had a case at the end of 2020, finally wrapped up after 4 years worth of litigation in federal court. It was a class action lawsuit. Went through the whole process, did not go to trial, but went all the way through appeal. And we prevailed on appeal in the Seventh Circuit Court of Appeals. So that covers Wisconsin, Illinois, Indiana, and felt really good to be vindicated on a position that we had taken throughout the case, and got a court of appeals to say, we agree with you. Felt really good. And it was an interesting bench, for the legal eagles in the audience. Judge Easterbrook was on it. Judge Wood, who at the time I believe was still the chief judge of the Seventh Circuit, and I believe Judge Sykes. That sounds wrong. I'm doing an injustice.
It wasn't the judge in the Kyle Rittenhouse case, was it?
No. That would have been a county. That would have been a state court.
Okay.
No, totally different. But anyway, so they were. It was a powerhouse panel.
It was a powerhouse panel.
What I'm trying to say.
And did you lead that? You led that? You handled that yourself?
I did. Yeah, I was the lead counsel in the trial court and then on appeal. And,
excellent.
It was cool. And it's a published decision, and all the rest.
Oh,
So
good.
yeah, there's that. And a lot of the moments though, frankly, where I get to do the best lawyering is when I have a client on a Zoom like this or on the phone and just talking through. And those are the ones that never get public because you gave the good compliance advice and it never became a thing because
Right.
you gave the good, here's the workaround for your problem, or here's the solution. And here's what I'll tell you that I've learned as I've progressed through my career on the compliance standpoint. Any lawyer can tell you no about your problem. Like, hey, we're thinking about doing this. And it's very easy as a lawyer to come back and say, nope, you can't do that because it's just safe. It's much safer to say, no, stay over here. But better and more experienced, wiser counsel will come around to, I'm going to give you sort of a spectrum of options. Okay.
Yep.
Here is a lower risk option. Here's maybe in the middle. And now we're in the so over here, this is the Cadillac sort of compliance option, gold standard, and goes down from there. And the associated risks change and morph, as do the revenue issues. And we really try to focus on that. That's the thing I'm always trying to lead clients to is what's the reason that you want to do this thing? Because it's tough when you get a lawsuit and you look at it and there wasn't a good reason for whatever happened or what was alleged to have happened. And maybe you're defending it. And that just seems like a loss. It's a lot better situation where you have a client that comes to you and says, we did this thing, X, Y, and Z. We were intentional about it. And here's why it's worth defending. And that to me makes sense because the economics of it just matter.
Well, you're a business attorney. I remember, I was a lender years ago, and we used a big, white shoe law firm in Boston, which is where I'm from, Goodwin Proctor. And the senior attorney at the time said to me, I'll never forget it. And it was exactly what you were saying. He said, it's about risk management, right? If there's not much risk with it, then forget about it. You know what I mean? Like, don't pay attention to things where you have exposure and risk, right?
That's where because you have limited resources. You
have
can't.
limited resources. And the other thing he said to me was, I said, you've been through this, and I was a real estate finance guy. And I said, you've been through these a million times. You've negotiated a ton of documents. Why don't you just come up with a document that's going to work? So he said, you know what? I tried that before. It got negotiated more than when I came out with like this boilerplate, heavily biased document. He said, lawyers want to redline things and rip them up. And so it doesn't pay.
And you're right. And he was right. I agree with that. It's a bit of a compulsion with the legal profession. It's like you feel like you've not done your job if you get a document and you look at it and say, perfect, right. I have nothing to add. It's as if you didn't, you've gone unfulfilled. You've not done the right thing. That's the problem with forms. The forms tend to turn off critical thought. If everybody just thinks, okay, press button, here's product.
Yeah.
That's when the details are not considered and people don't give it as much thought and deference. It's like the motorcycle analogy, motorcycle safety. The minute you stop being scared of it is when it kills you. Right. So for each legal problem, I think that's a very real risk of not saying I've seen it before and I know how this should unfold and I'm not going to think about the alternatives. It's just like a doctor who says, I've seen this brain scan 1,000 times. I'm only looking for these few things when in fact it could be something new, novel.
Yeah. It almost like begs you should be like starting everything from like scratch every time to make sure you're fully diligent about it, right? And don't miss things.
But the competing, so you're trying to find the balance between doing your very best job with the resources and what does the file, what does the matter warrant? Yeah. What does it justify?
Well, that's what AI is for. That's what artificial intelligence, right? To find those things that you might overlook. So are you using those kind of tools?
We use some
discovery and things like that.
We do, and we have clients that are really, really keen on introducing as much AI as they can into their processes. For one thing, and I don't mean this in a cynical way, but a huge part of overhead is paying people and payroll.
Yeah.
So to the extent that you can bring in technology that performs jobs or helps people do their jobs more efficiently, I don't think I have a single client that is not interested in that right now. And we're seeing it in the legal world. If you don't have a grasp on sort of fundamental ideas about emerging technologies, if you're not behind at this very moment, you will be very quickly, and people will run circles around you, whether it's in a transactional setting or in a litigation setting.
Yeah. Do you guys?
You have to.
Absolutely. I mean, in fact, I was going to ask you because I see in the larger, I don't know, you got, what'd you say? You're like 50 lawyers, but in the big AM Law 100 firms and even a level down, they have innovation groups, right? Where they just look at technology. That's what they do. They review and they find out where they can get some advantages from that. Are you doing that same thing?
We are not, so we don't have like a committee of folks that do it.
Yeah.
We actually employ, his title is litigation technology director.
Okay, so you have somebody. Okay.
We do, and he's actually he is a trained JD. He's not a practicing lawyer.
Yep.
And has worked in several in-house settings in the medical device world, and has a ton of computing and even programming knowledge. And so he's great in terms of identifying the things that you're talking about. Like what should we be doing next? And then also helps in cases. I brought him into complex discovery scenarios where we're getting demands on an ESI protocol or something, and working through that. He's been great. So on a smaller scale.
Yeah. No, interesting. Okay, that's good. I mean, you're a young guy, so I would imagine that you're not afraid of leveraging these things.
No. In fact, so here's what you want to see what I'm reading right now? So I'm studying for the IAPP.
Okay.
Test for certified information privacy professionals. And that's all law and regulation and theory and stuff like that, but none of that's going to be any good if I don't learn the attendant technologies and what some of the security weak points are.
Yeah.
I think that's the frontier for all civil litigation going forward. And we can check in on that. You can check me on my prediction in like 5 or 10 years.
Okay.
Even if it's not a data breach situation, every case is going to have some kind of component protecting, like in the commercial litigation world, protection of sensitive information. And we get further and further away from paper, more and more into housing all of this incredibly sensitive information in clouds, in electronic format, all of the rest. That stuff is going to become incredibly important. And so we're focusing an entire practice group on that.
Oh, interesting. Yeah. No, ownership of your information that's moving at light speed in everything. Healthcare. Well, it's always been a big issue in healthcare, but just people want to have ownership. I mean, with marketing. I mean, I know a guy in Colorado, in Boulder, is actually developing a product right now where people literally take back the ownership of their data. So Facebook can't market to them without their permission. So yeah, we're moving in that direction, I think, pretty quickly.
Yep. Yeah. People are understanding that they've been the product for a long time.
They're the product. Yep. And therefore I'm going to get paid for it. I'll give it to you when I want you to have it. It's going to be pretty interesting, actually. It's going to change the whole strategy of Facebook, Twitter, Instagram, those kind of businesses that rely heavily on, this data that people are giving to them, right?
Oh, I couldn't agree with you more. And to bring it full circle on the part about controlling a narrative in a litigation setting, as the technology becomes more complex and it's going quickly and it's developing at seemingly exponential.
Moore's law.
Yeah, it's just going to keep, right?
Yeah.
And so you have to be ready and in a position to have people who can educate the bench, because the bench typically is not comprised of really young people. It's just not.
Oh, we've
And
seen
so-
that when, what's his name? Mark Zuckerberg went before Congress. They had no clue how they make a living,
Right. And
right?
maybe if you're gonna be, he tried to bring it down to a level that was explainable in bite-sized chunks, but it's a challenge for a guy like him. When
Yep.
you were talking about it before, when you're the expert, you live in it every day, you forget what it's like to be somebody with
No knowledge. Yeah.
foundational knowledge. And so that's a great case study. That would be a failing strategy
Yes.
in trial. That is not what you want. You ultimately, you need to sell this vacuum to this group of people, right? And by telling them all of the high powered the motor and that technology and its energy consumption, so you might lose them. You give it to
It's
them.
so true. Everybody loves, and it's their baby, and they want to talk about every little detail. I do a lot of messaging and marketing for companies, and you got to remember the consumer doesn't have that same level of knowledge that you have. You need to simplify your message so they can understand it, right?
Yeah, I've got newer lawyers that should probably talk to you. That was so my dad was in sales. He did traveling sales and stuff like that, and then managed salespeople.
Yeah.
And he used to tell me all the time, and it really got my goat. Everything in life is sales, is what he's trying to tell me. I'm like, yeah, okay,
True.
whatever. But he was absolutely right.
Oh yeah.
So here I am saying, confirming that in a public forum for him.
Daniel Pink said that. Did you ever read Daniel Pink?
No.
That's what he says. Yeah, he's a pretty well-known guy, but that's what he says. Everything is sales.
I think he's right. He has to be. And
Yeah,
for lawyers, our jobs, are not in the marketing sphere, are not terribly different. It's a constant matter of talking to people about, it's persuading people, giving them your genuine self so they can trust you and put confidence in the things that you're telling them, and then help bring them to your point of view. And for us, that's a judge, that's a juror, that's a client, that's an opposing counsel. Every day we're living and breathing it, and our success and failure depends on what we're doing in the sales firm.
Right. Although sales is still kind of a dirty word. People still has a lot of stigma, right? The modern, but really sales is not about you actually use the word persuasion. It's really about sort of pulling them along and letting them discover.
That's
right?
it. No, that's it. You can't just beat people over the head. Nobody wants that. No,
Right.
You're gonna, in my view, and I'm not a salesperson, so I'm not really.
Yeah, but you have to do it in front of a jury or a bench. I mean,
do.
Right? Same thing.
And I can't stand up there and demand that somebody take what I'm saying as the right view. And that's why I think about it as education. That's
Sure.
my
Education. Absolutely.
Like
100%.
let me give you some facts, and then you do with it what you're going to do with it. And you're an adult and you're a smart person. You make the conclusion, and that is always going to serve you better.
Absolutely.
In both contexts.
100%. So let me ask you this: tell me why you became a lawyer. Like, where'd you get the desire to become a lawyer?
Yeah. Okay, so like the more romanticized, like looking back version of it is probably, so I worked
give me the real answer. I don't want.
Because okay, I'll give you two. And you decide. I'll let you be the decider which one you like better. The one is I did work for an in-house lawyer, and what I really loved is sitting in his office, and we'd have whatever the issue was, and sort of doing the war games and scenarios about how are we going to confront this issue, and having a light bulb sort of go off and say, I could do that for a living. People would actually pay me to do that. And if this is my favorite part of that story, is I actually asked him, hey, if you knew somebody who was thinking about going to law school, would you have any advice for them? And his advice was, yeah, don't. So
that was going to be my next question for you, but you just answered that. Okay.
But I obviously didn't take the advice, and I went anyway. But the second one is cynically in undergrad, I didn't know what I wanted to do, and it just became clear to me that the quickest way through the finishing my educational process and getting to a job where I could actually have a career, that's kind of where I put myself. It was that, or like teach high school, you know, I don't even know, English, maybe, if someone would be foolish enough to let a guy like me do that. So it was kind of necessity, and I got it right by half lucky, really, because law school does a terrible job of actually teaching people what the practice is about and what you need to succeed. And this won't surprise you based on our conversation.
Yeah.
A lot of it has to do with your ability to be your own person and have an outgoing, entrepreneurial kind of bent. And that is not a conversation that gets had in law school. And I got lucky that just happened to line up with what I'm about. And
Yeah, it's interesting. Listen, I could think you can say the same for business school. You can say the same. They don't really, that's one of the disconnects really with academia and the real world, right? Like that bridge to the real world. I still don't think academia does a great job with that, right?
no, it's unfortunate, but no, I agree with you.
Yeah. No, they don't do. I mean, because I went to business school, it's the same thing. It's like until you're like actually in the real world working and trying to apply some of the things that you learned in the classroom, it's like it doesn't really make sense. I mean, you kind of figure it out.
Yeah, no,
Right?
I think you're right.
So interesting. Good stuff. So let me we'll wrap this up. It's been an interesting conversation. If somebody wants to reach you and learn more about you, or get in touch with you, what's the best way to do that?
Sure. Email works.
Okay.
So my email is pnewman, Newman @Bassford. So Bass like the fish, Ford like the truck.com, pnewman@Bassford.com. Look me up on the website, give me a call. And I'm, your audience, I presume there'll be lawyers out there too. And I'm always happy to just talk about the profession and I don't just need people calling me because they want to hire me. That's great. I'm always happy to have those conversations, but talking to people about the profession and just maintaining a network nationally. Like I said, I practice kind of all over the United States. So I'm always happy to hear from people in other necks of the woods who want to make friends.
Excellent. Very good. All right. Well, listen, it's been a pleasure. Got to learn a little bit more about commercial litigation and financial, how you apply that to the financial services world. It's interesting since I have a background in that. It's been an interesting discussion. But thank you for spending time with us today. And you got your Callaway hat on, so I'm sure you watched the Masters. We'll let you get back to the next tournament. That was quite a finish.
That.
Although I have to tell you, I was rooting for McIlroy to come back. I have to admit.
Me too. It was
You
pretty
were
cool
too?
to see. Oh man, don't get me started. But that was a whole other hour. But yes, I
like Scotty Scheffler, but I was rooting for McIlroy to come.
I know. Come Ryder Cup time, we deny that we ever said anything like that. But yes, I'm with you. I like Rory too.
There you go. Anyway, so thanks again. Our sponsor is EmotionTrac, and EmotionTrac will use artificial intelligence to glean insights from nonverbal communication that people use for trials and mediation. And thank you again, Pat.
Thank you.
Bye.